I direct the National Immigrant Women's Advocacy Project at American University Washington College of Law. I want to thank you for joining us today. We have a very interesting and exciting presentation. I encourage all of you during the presentation to type your questions in the chat box so that the presenters can see them and so that we can be sure that we get your questions answered. Without any further ado, I'm going to turn over to our fabulous presenters, the presentation, so they'll have the maximum time available. Thank you, Edna Yang and Judge Briel, for joining us today. I'm turning over to you.
Good morning, everyone. My name is Susan Briel, and I'm a judge in the San Francisco Superior Court. I've been a judge for about 18 years, and my current assignment is a dependency assignment, so I deal with abused, abandoned, neglected children and reunifying those children with their parents if at all possible. And during my 18 years as a judge, I've had a number of different assignments. I ran our domestic violence court for 2 years. I've handled 4 years of juvenile delinquency cases and a number of serious felony criminal trials. It's a real pleasure to be here with you today, and I want to thank you for the invitation that you've extended me. Edna?
Good morning, everyone. My name is Edna Yang. I'm the Deputy Director at American Gateways. We're a nonprofit organization that provides immigration, legal services, and advocacy in 22 Central Texas counties. So I've been with American Gateways since 2002 and started out doing work with immigrant victims and still continue to do that work, and it's shifted my focus a little bit more towards deportation defense as well. So I'm very happy to be here this morning. I think we have a really great presentation for you all.
So we'd like to hear from you now that you know just a little bit about us. We'd like to know if you are A, a judge, or B, with the court and judicial education staff, C, an attorney, D, a victim advocate, or E, other. And if you're other, you can let us know who you are in the chat box. And we'll give you just a few more seconds to complete this questionnaire. Great. It looks like there's quite a lot of victim advocates. A minority of judges, there are court staff, there are other. Excellent. So let's see. Our learning objectives are to help you understand the impact of parental detention on U.S. citizen and non-U.S. citizen children alike. We want to help you understand the mechanisms in place to protect the parental rights of immigrant parents and how to use these mechanisms. And finally, we want to help you identify potential immigration relief for parents and children and your role in assisting them in applying for such immigration relief. So in the United States, we have a lot of mixed families. And by mixed, we mean a U.S. citizen child living with a non-citizen parent or family member. There are 4.1 million U.S. citizen children under the age of 18 living with at least one undocumented parent, 5.9 million U.S. citizen children under the age of 18 who are living with an undocumented family member, and roughly 500,000 U.S. citizen children who experience either the detention or deportation, removal, apprehension of at least one parent in the course of 2 years. And as of 2017, temporary protected status holders, TPS holders, from El Salvador, Honduras, and Haiti had an estimated 273,000 U.S.-born citizen children. And since TPS designations will be terminated, many of these parents will become undocumented by the end of 2019. Again, increasing all of the statistics you have on the slide. So it's really important to keep these statistics in mind as you think about the impact of parental detention in ICE. The detention or deportation of a parent puts a child at enormous risk of trauma and economic instability. And U.S. citizen children often end up in the child welfare system following the detention or deportation of a parent, because often the parent has not identified a caretaker for the U.S. citizen child, and so they end up in the child welfare system. And this is how these children often come before me and how I see them in court. And when the parents are detained by ICE, they may be separated from the child because the child might not be there. Maybe the child's in the park playing, or the child's in school, or the child's in church, or as in one case I had, the child was hiding in the closet. So they're separated from the parent who's detained, and they end up in child protective custody and in the welfare system. It is very hard then, and there are limited mechanisms to safeguard parental rights once the parent is in ICE custody. And it's very difficult for the parent to reunify from ICE custody with their child. There's significant barriers to reunification, even though Child Protective Services tries to implement or should be implementing a reunification plan. And there is a real misalignment with the timelines, because in state courts, it can take up to sometimes a year, sometimes 18 months for the reunification of a child with a parent, whereas the timeline for the removal and deportation of the parent is much, much shorter. So all of this impacts the ability to reunify and creates significant barriers to reunification.
Okay, so with that being said, I think that's a great point that Judge Briel made, that because of the different timelines, advocacy is really important in these types of cases to ensure that parents are asserting their parental rights, they're able to go to court, they're able to make choices about custody and make certain determinations about their children and what should happen to their children. So in 2013, to ensure that enforcement activities didn't unnecessarily disrupt parental rights of parents or legal guardians of minor children, ICE issued its Parental Interest Directive, which was pretty broad and also, I think, had a lot more force than the current one that was put into place on August 29, 2017. So the one from 2013 definitely talked about not disrupting parental rights of parents and how ICE could facilitate that. The one in 2017 still has that type of that goal, but it instead instructs ICE to remain cognizant of the impact enforcement actions may have on certain children. So some of the powerful language from the 2013 directive has been lost in this new memo, so I think that's important to keep in mind, but it's also important to keep in mind that the memo exists and that we should be trying our best as advocates and as attorneys to push the parental rights of individuals who are in removal proceedings to ensure that they are able to participate fully in proceedings, and especially where there's family, dependency, child welfare issues that come up. So the memo itself includes determinations, and it applies to proceedings where there are determinations or modifications of parenting plans, child custody, visitation, support, or the distribution of property, or other legal obligations in the context of parental rights. The directive itself it applies to ICE where certain minor children are encountered during immigration enforcement. And those agents should generally accommodate the parent or legal guardian's efforts to make child care arrangements before contacting local child welfare or law enforcement to take temporary custody. And if the parent is unable to make those types of arrangements, prior to detention or removal, then the child can be taken by CPS for placement and case management. One of the difficulties that arises with this 2017 directive, however, is that there are still significant issues for detained parents who are dealing with their immigration case and the custody proceedings, because ICE is not really required to inform CPS of a parent's whereabouts, and CPS may have difficulty locating the parent in order to actually join in the proceedings itself. So the faster that we can connect ICE and CPS and the child in the proceedings as advocates when we're working with immigrants who are detained or in removal proceedings, the easier it becomes to ensure that parents will have those rights. In order to facilitate that, the memo also directs that each field office will have a child welfare coordinator. And to find that child welfare coordinator, it's best to contact your local field office to see who that individual is, because they're supposed to have someone appointed that is the point person on placement and transfer of immigrant parents and legal guardians. They're the ones that you would coordinate with to arrange for escorted trips to court, to arrange for visitation in any of the facilities, and to help with arrangements for guardianship or travel with the child or parent if the child is going to return to home country, if the parent needs to be returned. They also have a point of contact to address public inquiries related to family or legal guardianship ties of a detainee. So it's important to find out who that person is in your field office first, because that's the person that you're going to want to connect with to make all of those arrangements. The directive also talks about minors who are encountered during enforcement actions. So it states that ICE shouldn't take custody of U.S. citizen or LPR children when they encounter them during any enforcement action, and they need to accommodate the immigrant parents or guardians' efforts to make care arrangements for minor children and not report those children to CPS or get them into a welfare system when they don't need to be. If the parent can't make those arrangements, that's when ICE can contact the local welfare authorities, or if they have indications of abuse or neglect. So Susan, have you seen some of these issues come up in your courtroom when there has been enforcement and a child has come before you, or you're trying to look for a parent or an attorney or a CPS attorney says the parent is in removal proceedings?
Well, every parent gets an attorney, a state attorney appointed to him or her. Even if they're in ICE custody, they get an attorney appointed. But what I've seen, just as ICE has no obligation, or they're not required to inform Child Protective Services about the parent, Child Protective Services and the social workers often are very uninformed about how to find that parent, where to look for that parent. They're not trained on the Detained Parents Directive. And so what I've seen is the absolute need to do a lot better education and training such as this one for the welfare system. And when I say system, I mean everyone involved, the attorneys, the social workers, the city attorneys, as well as the attorneys, private attorneys appointed, and of course us judges.
Yeah, I agree, and I think that you know, these memos can't be effective unless they're known about and unless they're used. And so getting this information to the people who can actually make things happen, the CPS workers, judges, and attorneys who represent immigrants in family proceedings is really important, because the more that we push on these memos to say these are created by ICE to allow a pathway for immigrant parents who are detained or at risk of removal to have access to the court system is very important.
What I'm also seeing is parents, non-citizen parents, not understanding the fundamental need to designate a caretaker for their U.S. citizen child should they unfortunately get into ICE custody. So I think that the word needs to get out to our immigrant parents that they need to designate someone, because otherwise the child may end up in a foster home, a stranger's home, and if they're maybe 10 or older, even a little bit younger, they could end up in a group home, and that's devastating for the child.
Yes, definitely. So a lot of the education can definitely be done with the clients that we serve in the immigrant community overall. So back to the memo itself, it does actually also talk about initial placement and transfer. So if a minor child or a family member in child welfare court proceedings are in a specific area of responsibility for ICE, then ICE must refrain from placements or transfers outside the area of responsibility. So that's important also, because you don't want to have a detained parent that's in a completely different state that's then trying to participate in the family court proceedings, custody, visitation, anything like that for their child. So making contact with the individual at the field office that coordinates that to say this parent needs to be in this area of responsibility in order to fully participate in the proceedings in the family court, and also pointing to this directive is very important. So the other thing about the directive is that it does allow parents to participate in the court proceedings. So it allows for the court to, especially if the court does order parents to be present at proceedings, the immigrant parent has to make a timely request to participate, and they have to provide evidence of the family court proceeding, including notice of hearing, court order, scheduling letter, or other documents. And so this is where there are a lot of coordination with family law attorneys who might not understand what the immigration process is and what is needed is really important, so that they're requesting the orders and things that they need from the court and from the judges to pass on to ICE, so that that parent can actively and reasonably participate in the family court proceedings. So the state and local court does have to be in a reasonable driving distance of the detention facility, and transport and escort of that parent can't be unduly burdensome. And there's not really anything defined in that, and so I think you can make some good arguments about, even if it's a few hours away, it's the only detention center that's there, and it's unreasonable to say that you're not going to transport a parent when what's at risk is really, is parental rights, is the ability to make decisions in the best interest of their child. If for whatever reason,
I would agree that 2 hours away is not unreasonable, because a child 10 years or older has the right to be present also, and sometimes even if the child is housed 2 hours away from court, we will continue the case so the child can be there, and I don't think it's unreasonable for a parent to exercise that parent's right to come to court, even if they're in ICE custody 2 hours away.
Definitely. If for some reason ICE pushes back and they say that it is unreasonable to transport or escort an individual to proceedings, they are supposed to make arrangements for video or teleconference participation. And this, I think, is really your fallback. I don't think this is what you want. I think there are limits to televideo, teleconference participation, especially when what's at stake is very high in terms of decision-making for the children, for custody, guardianship. If there are claims of abuse or a neglect, you want to make sure that the parent has every opportunity to fully participate in those proceedings. So, Judge Briel, have you seen types of cases where parents have been transported, where they're either in immigration custody or some other type of custody, and how has that worked in your courtroom in the past?
Absolutely. The parents have a right to participate. So we have many incarcerated citizen parents who are incarcerated either in county jail or state prison. Often they are brought to court. I mean, sometimes it's not a pretty sight. They're brought to court in their jail garb, sometimes in shackles, and sometimes if they are in a state prison facility that's a little bit difficult to transport from, they will participate either, usually with telephone, and they'll be on the phone, on speakerphone, but they have a right to participate, just like our non-citizen parents have a right to participate in the proceedings. They have a right to visitation in ICE custody the way our incarcerated citizen parents have a right to have the children go and visit them in the county jail facility. They have a right to communicate with their child, write letters to their child, be updated on health situation or dental situation of their child. It's no different than any other parent, whether the parent is out of custody, in custody because of a criminal act, alleged criminal act, or in ICE detention.
Great, and I think the other important point to make as well is that it is the responsibility of the detained parent for getting the approval to participate in some manner, right, through their attorney. So either saying, I want transportation, I want to participate, and getting the court to order that, or if that's not possible for ICE to do that transportation, to obtain the orders from the court and the approval from the court to appear telephonically or via televideo as well too. And if for some reason that parent who's detained doesn't want to participate, that is of course their right as well too. And in those cases, ICE will, they won't interfere with that decision, and they'll document it for their files as well too. And that's something that you can use in state court, especially if you might be representing an individual who is the not detained parent, and there is some custody issues that are going on there as well.
Yes, but even if they don't want to participate, Edna, notice by the state court is really important, and it's an obligation of the government attorney to give notice to the parent in ICE detention, whether they want to participate or not. It's also the obligation to give notice to a parent who's already been deported, which can be really a little tricky because sometimes, you know, the address for notice is 2 blocks behind the post office in some very rural town, but notice is required.
Okay. Yes, that is very good to point out as well. The 2017 directive also allows for visitation, and so I think this is really important to push back on ICE for as well, to have the parent be given their visitation rights, especially if they're already court ordered and they have the right to visit their child, then they should be allowed that ability. So if ICE must arrange for visits within the first 30 days upon request of the parent. If for some reason that facility doesn't allow visitation, contact visitation or whatever type of visitation that is ordered by the court, then ICE must consider a transfer to a facility that will allow visitation. And then upon request, ICE must continue monthly visits until a transfer has occurred. So whatever type of visitation they can arrange, they need to make happen until some sort of transfer happens to another facility. So visitation, I think, is something that is oftentimes forgotten about because we're thinking about like the custody issue in general and the end game of what is going to happen to the child and what's in the best interest of the child. But visitation is really important to a parent and a child in order to foster that connection and to normalize things for them, and can be helpful in alleviating some of the trauma that has occurred when a parent gets detained as well too. So that is something that I think that all of us as advocates and as attorneys need to push back on for ICE to ensure that visitation under this directive is maintained. Again, ICE must facilitate court-ordered visitation to the extent practicable within the required visitation within those orders. And then if there is no in-person visitation, if it's not something that ICE can do because of the facility that the parent is at, there's no other facility to transfer that parent to that's in the area of responsibility, then they can also permit video or teleconference visitation if it's technologically feasible. That has to be approved by the family court or child welfare court. So that's some more coordination that does need to be done if for some reason in-person visitation is not allowable. So when parents are being removed and they have parental rights to children, ICE needs to accommodate the efforts of parents to make arrangements regarding their children, either to have them remain in the U.S. if that's what they want, with a legal guardian or with someone that they've designated to take care of their child, or to travel abroad with the parent. So ICE must afford parents access to counsel, consulates, consular officials, courts, family members, to execute all the documents that are necessary, purchase airline tickets, make travel arrangements that are necessary prior to their removal to make sure that they are reunited with their children. And they have to provide notice of the removal itinerary in order to coordinate travel for the minor children. And I think that's really important, because sometimes that travel itinerary for removal can happen really quickly. And so you want to make sure that you push on that to see when that parent is going to be removed, if that is what's going to happen, and how that child, if they're going to rejoin their parent, how those travel arrangements can be made. If child custody is still being determined, it makes it much more difficult. And you want to try and get those determinations about custody and decisions about where the child is going to go, who is going to care for the child, completed prior to removal. Because once removal is effectuated by ICE, then ICE really has no other, they don't have any guidance to facilitate assisting the parent at that point once they're back in their home country. So they're not going to help facilitate any type of documentation or things to get the child back to the home country if that is what the parent wants and that's the best interest of the child, or they're not going to help facilitate anything for that parent if the child should remain in the United States. And once the parent is removed, then you have to work with consulates, you have to work with a whole bunch of different agencies to try and make arrangements for a child, and it becomes much more complicated. So really pushing while the parent is detained in removal proceedings and in the United States to get the custody proceedings to match up with the removal proceedings is important, just because once that parent is removed, a lot of that becomes much more difficult for everyone involved. Here is the ICE contact information that we have as of March 2018. So in order to find a parent who might be detained, one of the best systems to use is the detainee locator system, although it does have its flaws. The best way to find an individual is through their A number, which starts with the number, or the letter A and has 9 numbers, and their country of origin. You can search by last and first name and date of birth, but if there is an error in how immigration has, or ICE has put in the parent's name within the system, if they don't use both last names, or if they hyphenate a last name, or if there is some sort of misspelling, then that person won't come up in the system, and you won't be able to know where, you won't be able to find them, and won't be able to find where they're detained. You can also, if you don't know the A number, the detainee locator system isn't working, you can call the detention reporting information line and see if you can find out where the parent is using name and date of birth. And then any inquiries regarding the detained parent directive, there's a specific email that ICE has where questions can be sent. So if you are having trouble finding the point of contact for your field office and you've made several calls and you don't know, you can also email this system as well too, through the parental interest email to find out who that individual is.
So for those,
also,
I just want to say, for those judges and court staff who are on the webinar, this is really, really vital information to give to your family court personnel and social workers who are looking for parents. And then also NEWAP has all of these ICE policies on our web library. There's a section for detained parents, and so you can have access to everything that we've talked about today as well too, so that when you're talking with ICE, you can read through all the memos prior to it and have an understanding of what ICE's obligations are within the detention and removal system, and in regards to how it aligns with family court cases. So, Judge Brewer, what do you believe is the role of the state courts in preserving parental rights for immigrant parents who are detained? Well, I think first and foremost, a judge always has to decide what's in the best interest of the child. But in order to decide what's in the best interest of the child, we have to ask whether the parent wants to reunify with the child, and it's our mandate to try to reunify the child with the parent if at all possible. Sometimes, many times, parents really do want to reunify even though they're in ICE custody or even though they've been deported. Other times, the parent might, after consulting with their own immigration attorney, and all parents in ICE custody should have an immigration attorney and should have a family law attorney, because there's different types of laws and types of timelines, and the parent may decide they would rather stay in the home country and have their child apply for certain types of immigration relief that are available in the United States. But it's really important to, it's almost always in the child's best interest to reunify with the parent if that can happen, and that means having a plan of reasonable services to be provided to the parent for reunification. It is not clear, and there's no clear cases on point about what reunification services look like for a parent in ICE custody. If an argument is made by the parent's attorney that they have not been provided reasonable services by the state court while they're in ICE custody, then the timeline for reunification should be extended. But I think the role of the state is to try to reunify the child, and also figure, and it gets so complicated that it's very important to develop transnational policies among the state courts. And I'm defining transnational as involving a family with close family members and meaningful ties to at least 2 countries. Because, as we saw previously from what Edna was explaining, it gets very complicated with consulate officers and transportation of a child to see the parent in ICE custody, or even flights for a child to see their parent in their home country. And so it's really important to have a transnational team or a policy and consult with the consulate to find out what the home would be like if the child's going to go back to the home country, what the home situation would be like. So there are a few bullet points of what I've been talking about. Consider what's in the best interest of the child. What does the parent want? Does the parent want reunification? And what will reunification look like? What are reasonable services to the parent, reunification services while they're in ICE detention? Are there transnational policies? And can the consulate of the country of origin provide assistance in inspecting the living situation of the home country, or in providing transportation or visits to the home country? So the judge's role in these cases, as in all cases really, is to make really detailed findings, especially if the parent is able to come to court, to make findings about the situation with the parent. If there's only one parent in court, where is the other parent? Was the parent abusive in any way? Was there a battering situation? Was there an abandonment of the child by the other parent who stayed in the home country? Was there extreme cruelty to the child by one parent in the home country? Was there abuse, abandonment, or neglect? Because all these findings that we make as judges will help a parent or a child qualify for certain types of immigration relief, and we're going to talk about that in just a few minutes. And Congress did create a special role for us judges in making findings for U visa certifications, T visa certifications, special immigrant juvenile status, which we'll also go over, because this is what we judges do every day. We make these findings about what's in the best interest of the child, who would be the best caretaker for the child, who should have custody, and has the child been abused or neglected or abandoned. Also, I think it is the role of the judge to distribute pamphlets like Know Your Rights, which is a document produced by the Department of Homeland Security, especially because many non-citizens, whether undocumented or not, are afraid to access the justice system and the court system. So having transparency and informing participants of their rights, litigants of their rights, is really important. And giving out these government brochures so that parents can know their rights is extremely important.
So do you want to talk a little bit about child custody and immigrant rights, Judge Grill?
Well, parents have an absolute right to have their child absent unfitness. And this applies to all families, irregardless of their immigration status. And it applies to families even if they've been deported. The parents have a constitutional right to their child unless they do not want to reunify and do not want to access reunification services. Parents, even if they're living in a country like El Salvador or Guatemala, have the right to participate in the state court proceedings. And we've had parents who call in at like 2 in the morning their time to be part of the reunification proceedings or the contested reunification proceedings. So the overriding presumption is that there is a constitutionally protected parent-child relationship, and it's in the child's best interest to be reunited with the parent. And we're taught, you know, way back in Judges College, if a child is removed from the parent, we must return that child to the parent if at all possible. And it's important to figure out what is in the best interest of the child. So a question comes up often for us judges about whether immigration status is relevant to custody. And I have to say that immigration status is certainly relevant if it is the non-citizen is being abused, and if their immigration status of a non-citizen is being used as kind of a weapon and part of an overall pattern of coercive control of that person, of abuse, of threats to have the person deported if they report the domestic violence, say, to the police, threats to call ICE on the non-citizen parent if they don't do what the abuser wants them to do. So in that sense, immigration status is relevant to an overall pattern of abuse that's even more insidious than your normal kinds of power and control and abusive relationships, because of the fear that many non-citizens have of being deported, of the fear they have of the citizen or the lawful permanent resident they're relying on not giving money to their family back home, turning them over, reporting them if they're working. It's certainly not relevant to who the primary caretaker should be and that determination by a judge. It's not relevant to parenting skills. Citizenship status is not relevant to determining the best interest of the child. And it's not relevant to determining custody awards. It's much more important to give custody of a child to a non-citizen nurturing parent than to a citizen abuser. There are a lot of myths about parents who do not have legal immigration status, and one is that deportation is imminent. And we know that the Department of Homeland Security policies really do try to prevent detention and removal of immigrant parents who are crime victims who are in the process of applying for a U visa or a T visa or a VAWA self-petition. If they are in the process of accessing these remedies, And the other myth is that parents are likely to flee with the U.S. citizen child, or they're likely to flee the United States. And really, the number one fear of battered immigrant women, according to the National Institute of Justice, is fear of deportation or removal. But the number two fear is that the U.S. citizen parent will flee with the child, because the U.S. citizen parent has documents that allow him or her to travel freely, unlike the non-citizen. But it's a myth that the non-citizen is likely to flee with the child. In fact, there is a federal case that we can certainly provide, which is Lopez Valenzuela versus Arpaio. And that's a federal case from 2014 that says there is no evidence whatsoever that undocumented status correlates with flight risk. So a further myth is that a non-citizen parent has no livelihood, because we know that immigrants who are accessing immigration relief have a pathway to work authorization and some benefits. And finally, there's a myth that legally, that the parent must have custody in order to file for benefits for the child. And custody does not affect a parent's ability to file for immigration benefits for a child. So I guess I have a question for you, Edna, and the question is whether the transportation of an undocumented immigrant parent or child would be considered a violation of the law. And how this came up for me is we had a child that needed to be returned to Guatemala and reunited with the grandmother in Guatemala. And that's what everyone wanted, the parent's attorney, the child's attorney, the city attorney for the government, the social worker. But there was a concern, since the child was a non-citizen, that if the Department of Human Services, Social Services, in other words, Child Protective Services, transported the child, they would be violating federal law and could be arrested. And it also has come up when children who are non-citizens need to go to out-of-home placements and delinquency cases, and probation at times has been very hesitant and full of trepidation about transporting a child who's a non-citizen to these placements, saying that they will be harboring a quote-unquote illegal alien. And I've also, it's come to light that some shelters also are concerned about giving services to non-citizens and violating federal law, and I'm hoping you can weigh in on this as our immigrant expert.
Sure. So you're right that there is a federal law that exists that makes it a crime to transport or attempt to transport a non-citizen who's undocumented within the United States. But the way that the law is written, it's actually meant to cover much narrower situations than the ones that you're describing. So the law itself can be found in the Immigration and Nationality Act at Section 274. And I won't give the full site because I don't think that's as useful. But in order to convict someone under this section, prosecutors need to show 4 different things. First, that the person transported or attempted to transport a non-citizen within the United States. Second, that non-citizen was in the U.S. in violation of U.S. law. Third, that the person was aware that the non-citizen was in the U.S. unlawfully and acted in reckless disregard of this fact. And fourth, that the person acted willfully in furtherance of the non-citizen's legal violation. So I think the main question about this is, or what it turns on, the question that this whole law turns on is whether you're attempting to further the person's legal violation, if one exists, by transporting them within the United States. And so the classic situation that this law is really meant to address is a driver who picks someone up at the border and then transports them further in the United States, and they know that they're doing that, and they know that they're doing it in furtherance of violating the law of assisting individuals to enter the United States or move within the United States in violation of federal law for their undocumented status. They haven't been inspected, they're here uninspected, undocumented, and they're trying to get further into the United States to kind of evade any type of detection. But that's not the cases that you've described, right? When you have an individual that's helping someone who might be undocumented, and you're transporting them you're trying to transport them to a place where they can then leave the United States to reunify with their grandmother, it doesn't really fall within the criminal elements of this law. Or you are a shelter worker, or you're a CPS, and you are trying to transport this individual to a court hearing or to a safe place, you're not really furthering their legal violation of being here undocumented. The other thing to remember is that some of the individuals might actually have some claim to status in the United States as well too. So I have never seen a prosecution of a CPS worker or a shelter worker for transporting someone who may be undocumented within the United States. There's also a court case out of the Ninth Circuit that says that the act of transporting undocumented workers from one site to another is not considered a crime under this law. So courts have already kind of weighed in on this as well, looking at what the intent of the law is and what the intent of the person is in transporting an individual from one place to another.
Thank you. I am writing down his answer word for word.
So the other thing that we want to talk about today in this session is that there are, we talked about just immigrant parents in removal proceedings and immigrant parents who might be at risk of removal, but we haven't really talked about if there's any relief for those parents. So, because a lot of the parents who do come under any type of enforcement action, there is relief available to them, and I think that's important to keep in mind, that you're not really preparing an individual for removal in the end. You might be coordinating with an immigration attorney that has identified some sort of relief. And this is really important when there are immigrant victims, because a lot of times immigrant victims don't realize that they have relief available to them until they're educated about it, until certain questions are asked about their situation and why they were picked up by ICE, why they're here undocumented, what their ties are to the U.S., and whether they can apply for one of these things. So the Blue campaign through DHS has kind of outlined the protections for immigrant victims, and we'll go briefly through some of these as well too. But I think the most important thing to do, especially if you're not an immigration attorney, is to kind of screen for these things and ask, are you a victim of any type of crime? Have you reported any type of crime to law enforcement? Are you suffering from domestic violence? Do you have a fear of going home to your home country? Those kinds of questions to kind of evoke answers to see, are they going to be eligible for some sort of protection under the immigration laws? And if they are, who can you then refer them to get the assistance that they need in order to apply for those types of relief as well? So DHS has repeatedly said that it has a victim protection rule. So statutes and regulations also create this victim protection rule. So there are protections for victims of domestic violence, child abuse, sexual assault, stalking, human trafficking, and other crimes. And this is very clearly laid out in statute and in regulations that DHS has this role. There's also a victim witness protection memo that DHS has said that even now is under effect. So it's, again, looking at the memo and reviewing it and making sure that DHS follows its obligations not only under the law but under these victim witness protection memos as well. And the law also lays out something called vow of confidentiality to ensure that information about victims are not disclosed to individuals or not used against them when they're applying for certain types of relief, such as VAWA, T visas, or U visas. So VAWA confidentiality within its computer system that they have at DHS is very important, especially when you have a survivor of domestic violence, a victim of trafficking, a victim of a certain violent crime, that might be able to apply for either VAWA relief, U visas, or T visas. So what is the confidentiality system, or the confidentiality law, which is called Section 384, because it's that section of the immigrant, of IRA, essentially. But it directs DHS to red flag that case within their computer system as a victim-based immigration case, and then certain protections attached to that case. So it allows victims to have protection against immigration enforcement, against removal, against detention, against use of information, and reliance on information from perpetrators of the crimes in these cases. So if it is a domestic violence case, or a child abuse case, or an elder abuse case, the abuser can't call immigration to find out information about the individual or give information to DHS about the individual that would harm their immigration case as it's pending. Same for crime victims. You know, if you have someone who's a sexual assault or stalking or a human trafficking victim, those perpetrators can't try and interfere with the immigration case and say that this person really isn't a victim, they did all these other things that are illegal and they don't qualify for whatever they're applying for. So those types of protections attached. Valid confidentiality also precludes courthouse enforcement against victims. And I know there have been several cases where courthouse enforcement has actually occurred, but those have been in violation of the law for valid confidentiality. And I think it's important to push back when that happens, to file complaints, and to make sure that the valid confidentiality law is being used in the way that it's supposed to, and that it provides the protections that are allowed. Even if there are violations, there are certain remedies that can be done to undo any harm in terms of enforcement actions against victims. And ICE has a policy of no enforcement in family and civil courtrooms and cases absent head of field office approval. So that's also important to note as well too, because you don't want an immigrant parent who wants to get custody or who needs a protective order or who needs a divorce afraid to get those things and access the justice system when they have all rights to do exactly that. The different types of relief provide benefits for adult victims, child victims, and certain family members, like their children, if there are adult victims. So it protects them from deportation. It provides that confidentiality protection. It can enhance safety for survivors, especially through valid confidentiality and by having DHS kind of come in through that protection role. It can provide temporary legal immigration status, protections for immediate family members like children, sometimes siblings as well too, who are under 18, and it can provide financial independence from a perpetrator of a crime, and just financial independence in general for an immigrant who maybe didn't have that before. So they're eligible to get legal work authorization. In some cases, they can get access to public benefits and services, such as child care, foster care payments, health care, financial aid, food stamps, things that will help them become independent and will also help them. Yes.
I'm sorry to interrupt you really quick. We're getting a little bit of an echo coming from your line. Can you adjust how you're holding your phone and see if it gets better?
I think it's coming from me, and I'm hearing double. I'm hearing an echo.
Okay.
I think
is this better?
Stopped.
All right. Can you try again, Edna?
Sure.
Sounds great.
So so that financial independence is something that's really important, and once you screen for the types of benefits and relief that are available to immigrant victims, then that allows for the individuals that you're assisting, the immigrants that you're assisting, to access all of these protections. So we'll go through each of the different forms of relief fairly quickly, just the elements of them, because we don't have much time, and a lot of this information is also available in our new app library. But for valid self-petitioning, it is something that's available for an immigrant who's been subjected to battery or extreme cruelty by a U.S. citizen or permanent resident spouse, parent, step-parent, or citizen adult son or daughter who's over the age of 21. So what it allows is individuals who are victims of family violence to apply for their self-petition and eventually their lawful permanent residency without the assistance of an abuser, an abusive family member who essentially under the regular immigration laws would be responsible for assisting an individual to legalize their status and get their lawful permanent residency. So it's important to keep in mind and ask questions about whether an individual has suffered domestic violence, some sort of abuse or neglect from a parent or step-parent, or if they are elderly, if they have an adult son or daughter, if they've also suffered abuse from that adult son or daughter. A T visa is for individuals who are victims of a severe form of trafficking. So that can be sex or labor trafficking involving a victim under 18 or an adult subject to labor through force, fraud, or coercion. They have to show that they're present in the U.S. on account of the trafficking, and they have to comply with reasonable requests for helpfulness in investigating or prosecuting the trafficking, which also means they have to report the trafficking, or the trafficking has to be reported. And the exceptions for this compliance are for victims who are under the age of 18 or the victims who have a physical or psychological trauma that impede cooperating with law enforcement. They also have to show that removal from the U.S. would cause extreme hardship. So to screen for these types of cases, we often ask about documents being taken away, any type of work without pay. If it is sex trafficking, we ask about, and it presents as a sexual assault case at first, we do ask about the nature of the sexual assault, whether it happened repeatedly, and anything that would point to sex trafficking as well.
So for
Judge Brill, a bit about
yes,
the visa requirements?
You have to be a victim of certain qualifying criminal activity. You have to either have been, are being, or likely to be helpful in the detection, investigation, prosecution, sentencing, or conviction on a case, and have substantial physical or mental abuse as a result of the crime. Obviously, the criminal activity has to have occurred in the United States, well, maybe not so obvious, or violated United States law. So here's a list of all of the qualifying crimes, but this also includes, this list, any related crimes or any attempts. And on this list is trafficking, is domestic violence, kidnapping, fraud, witness tampering, and certainly if you're threatening to have someone deported if they report a crime, that's a kind of witness tampering. So this is a list, but it's in no way exclusive because of all the attempts and related crimes. Helpfulness as a matter of law is in the investigation or prosecution and is defined as investigation or prosecution, detection, investigation. I mean, judges don't investigate. And so judges are allowed to sign these visa certification forms because if there's merely the detection, that's enough. Even though the language might say investigation or prosecution, judges don't prosecute either, but often are in a position to detect one of these qualifying crimes where a victim has been helpful. So just moving on, if the certifier believes that the applicant is a victim of a qualifying crime and the victim has knowledge of the crime or is likely to be helpful in the detection, investigation, and prosecution, those are the three things that need to be certified. It is not a requirement for a certifier, such as a judge or a law enforcement officer, to find that the victim suffered physical abuse. It's not something that's needed. Also, there's no statute of limitations for when this helpfulness occurred or when this crime occurred, and it is any credible evidence standard, and those are really important to keep in mind. Here are the types of court proceedings where a judge might detect helpfulness: in a family court proceeding where there's a domestic violence restraining order, a custody case where there's abuse, or the reporting of child abuse or physical abuse, neglect, termination of parental rights. You might see helpfulness in all these different case types: divorce, paternity, juvenile delinquency, criminal elder abuse and probate cases, or civil cases, cases involving sexual abuse in the workplace, tort damages. All of these places is where helpfulness might first come to light. Why might a judge, strike that, why might an immigrant child victim or parent come to a judge for certification? And you can, is it because a child victim parent sought protection order? There was evidence of abuse provided in a child welfare or custody case, or the police were called, but there was no interpreter. All of the above. There was no language access. Why all of a sudden later on in a restraining order case that has nothing to do with a criminal case might the helpfulness come to light? And it looks like just about all of you are saying all of the above, which, oh, it's 100%. That's so great. As we say in Latin, you are all correcto mundo on that. So
Judge Bill, have you ever signed a U visa certification, and can you tell us a little bit about the circumstances surrounding those cases?
yes, I actually am the sole U visa certifier for the Civil Division of the San Francisco Superior Court. So I sign these all the time. I sign cases where maybe 10 years ago someone sought a domestic violence restraining order and brought to light 10 years ago an instance of domestic violence. Again, it fits all the criteria. It doesn't matter that it was that long ago. The person had been helpful to bringing to light one of the qualifying crimes and helpful in the detection of that crime. I sign them, and I have absolutely no problem signing them. The standard is so low, it's almost like a probable cause standard, and it's much like signing an arrest warrant or a search warrant. And it's not too often do I sign the ones with a pending criminal case, and those often are handled by an expert in our police department, Inspector Flores, Tony Flores, who trains a lot on these issues and signs off on the U-Visa certification. So we have gone over this really quickly because there are also special immigrant juvenile status webinars and U-Visa webinars provided by Leslie's organization, NEWAP, and you have the links there, and there are going to be links to past webinars. Here they are, and webinar resources right here. So we know we've gone over that really quickly because there's such a wealth of resources that American University has put out along with the National Council for Juvenile and Family Court Judges. Any final
and the last thing I would, the last thing I would say is to thank everyone for their time. If there are specific issues on very specific cases where you all need assistance or technical assistance, you can always contact NEWAP. It's free technical assistance. You can call the technical assistance line. You can email us, or that you can find information on the web library. But if the web library isn't as helpful to you because there is something more specific, please feel free to reach out.
Thank you, Judge Brill, and thank you, Edna, and thank you, the council. I just wanted to reach out to you all and let you know about the technical assistance that we provide. We would be happy to help you in any way through the number or through our email line, and also we also have